Your Honor, we would like to make a record on the mistrial motion for prosecutorial misconduct. Do you want to do that after the break or now?
Let's do it now.
Your Honor, and I do not have the exact date, but in prior pleadings, when Ms. Arias had requested copies of the text messages, the state had constant refrain in these things was that we were asking for things that didn't exist. In previous testimony, Detective Melendez was on the stand. He was asked if he looked through these messages.
Mr. Nermi, before you proceed, I'm going to ask the witness to please step down and out of the courtroom while argument is occurring. Please return in approximately 10 minutes. Witness has left the courtroom. You may proceed.
Thank you, Your Honor. Apart from, again, the state's assertions in their motion that these didn't exist and the resistance of providing these in discovery, and this has been going on for over a year now, Detective Melendez on June 18th, 2010, we were in front of Judge Duncan. He was asked, related to text messages and emails, did you look through everything that came up? Is that correct? Yes. But you did not make note of specific content, nor did you print out of any content. He says, is that correct? Either emails or text messages. He says either. He says no. But then again, in the prior testimony in January, he had talked about going through every single email. Here, during the course of this trial, he says he didn't have time to go over everything. That would take 8 months. So clearly now the testimony has changed. Based on what Detective Melendez has told us, these text messages existed in 2008 when he first retrieved the phone. That is in direct contrast to the state's prior pleadings and his testimony today regarding what he did with the text messages is in direct contrast with what he said before. Of most prominence to this situation, of course, is what the state has done in terms of asserting that these messages didn't exist in face of Ms. Arias' continued discovery requests. And what I would say to you now is, having heard the detective's sworn testimony at trial, that we have deceit on the state's part regarding to the existence of these text messages when they were inquired about back in 2009 and 2010, which motivated these hearings in front of Judge Duncan. And, Your Honor, we have put forth motions of prosecutorial misconduct in front of Judge Duncan. At that time, we have renewed it again now, prior to now, previously in written motions, and I would renew that again. And I think what I would remind the court is, and I can't cite the exact case at this point in time, but one of the things we look for is the cumulative effect of the misconduct. And the misconduct in this case is growing, warranting a mistrial.
Mr. Martinez.
The court must keep in mind that this issue has already been litigated. Not only has it been litigated, it has been litigated ad nauseum before Judge Duncan. And at some point, there has to be a duty of candor that the court has to take notice of on behalf of the defense counsel. Why didn't he cite you? If he's going to make this motion and accuse somebody of deceit, why doesn't he cite you to the transcript of Detective Melendez? I don't know who he's talking about when he talks about Detective Flores. This issue involves Detective Melendez. Perhaps all Hispanics, their names sound alike to him. But the bottom line, I'm not done yet. With regard to this issue, there is a duty of candor. And the duty of candor applies to both sides. This issue was litigated over and over and over again without reference to the transcript. At that time, Detective Melendez indicated that he couldn't get these text messages. He could look at them, but he couldn't get them in the sense that he couldn't extract them so that he could print them out and give them to somebody. That's what he testified to. He also testified that he looked at some of them, but if they wanted him to take photographs, that it would take him too long for him to do that. Subsequent to that, and what is going to be shown on redirect is that technology was developed. After the technology was developed, there was 896 pages of text messages that were obtained. There was approximately between 25 and 30 text messages per page. I don't know if that equals 20 or 30,000 text messages, but it would have been impossible for him to sit there and take a photograph of each text message unless he had months and months to do it, and they were not going to do that. So the bottom line for the state is these motions for reconsideration, where they're highly inflammatory without anything to be backing them up, at some point require a measure from the prosecutor to say other than what he has only said up to this point is let the record speak for itself. The record speaks for itself, and the record speaks for itself, and if there's any deceit, it involves the duty of candor of counsel. Thank you.
Mr. Martinez, I want to make sure I understand what you just said. When the technology became available, these text messages were retrieved from the phone and made available to defense counsel. Is that correct?
That's true, and that was approximately 2 years ago.
All right. Mr. Nurmi.
What happened in the pleadings, we talk about duty of candor, what happened in the pleadings, and I might add inflammatory comments regarding from the prosecutor to the defense counsel are totally inappropriate and demonstrative of the continued prosecutorial misconduct that we're experiencing in this case. What the state said, not that there was no technology or anything else, what they said in pleadings, and he's right, I don't have the exact pleading right now, but that they didn't exist. We kept asking for them in motion. He said that they did not exist. That was the response from the state. It's seems to be the constant refrain to all this. There was nothing about technology or updates or what have you. As a matter of fact, and I will refer the court back to the testimony in regard to weighting this issue, on January 10th of 2010 and April 20th of 2010, because this was subject of much litigation, and the court can go back to the records of those proceedings in front of Judge Duncan. And what we will see is that Detective Melendez did testify to something different now than what he testified to back then. Then he testified to, I looked at a few, I didn't photograph any, there weren't any on there, and I just gave it back to Detective Flores. I didn't take any photographs. He did not talk about seeing all these messages because back then that would have motivated inquiry as to why they weren't handed over. And what we have now that we're in trial, the story changes. And again, Judge, when we talk about candor, we've had demonstration throughout the course of this trial that what was supposedly true to the state when they were asserting denial of discovery motions in 2010 has now changed in 2013 when we get to trial. And there is a candor problem called prosecutorial misconduct. It is cumulative, and it does warrant a mistrial in this case.
Mr. Nurmi, have you had these text messages for 2 years, or approximately 2 years?
Yes. I can't say it was subject to litigation in 2010. I don't know when we got them in 2010. We do have them, but that's not the point. The point is the fact that we're hearing testimony now that they were available in 2008, and in 2010, when this litigation was going on, the state denied their existence. That's the point. They were eventually forced through Judge Duncan's order, and through this extensive litigation, they were eventually ordered to turn those over. But prior to that, they claimed that they did not exist. What we heard today was that they did, in fact, exist in 2008 when Detective Melendez did his report.
And what prejudice did your client suffer as a result?
Judge, the prejudice to my client, obviously we have Brady violations, Your Honor. We have Brady violations to which I don't, and obviously I haven't had time to brief this issue. I don't know that prejudice is required under a Brady violation when there is direct hiding of exculpatory evidence. Because we will see later these text messages, and we've put it in pleadings, that there are text messages of a sexually graphic nature that are exculpatory that demonstrate the abusive nature of the relationship. This caused, I might add, a great deal of delay in this trial because it took months of litigation for the state to turn over what they already have. This is why part of the reason why we're doing this trial in 2013 instead of 2010, because we had to litigate it, and once we did, then our experts were confronted with thousands of text messages. There was probably more than 800 pages. I can't speak to that directly, but there were thousands of text messages, emails. I have notebooks full of them, all that needed to be covered because the state back in 2008 did not come forward and provide these to Ms. Arias.
All right. Well, I obviously did not preside over the evidentiary hearing in 2010, so I will need to go back and look at Judge Duncan's ruling and the pleadings related to that evidentiary hearing. I will give you an opportunity to provide additional support for your motion in the form of transcripts or anything else that you would like the court to review. The same with the state if there's anything else. So I will take your motion for mistrial under advisement, and once I have had an opportunity to look at these materials, I will rule. We're going to take the recess.